Hello and welcome to another edition of Questions for Lawyers. Today we have an old friend visiting us from afar, from parts unknown, my good friend Matthew Konecky, who is a two-time member of the Questions for Lawyers Club. Matt, thank you so much for joining us.
Jeff, good to see you as always, especially, I'm glad we can do it from afar.
Absolutely. Well, this is kind of a very strange time for all of us in our lives and in our law practices. And I thought today would be a good day for us to kind of talk about the differences that you've seen in your practice, whether it be on the civil side or on the criminal defense side, which you do criminal defense, which I'm not involved in. And I thought that the audience would be very curious about how things have changed over at the courthouse for criminal defendants.
Well, it's like everything else. It's changed dramatically. And, when we first got the order that basically either the courts were closing, that just sends everybody into upheaval. Especially criminal defendants. And then I know there was a great concern with those who were in jail at the time. And essentially, so when we first looked at when the order was placed by the Supreme Court of Florida, they suspended a defendant's right to a speedy trial. And that's crazy if you think about it. That's rarely happened. It's happened a few times. There may have been a few times during, we've had hurricanes, but those are temporarily, in a week, a week or two, a month, you're going to get power back and things are going to go back to normal. And here we are, right now, the Supreme Court has extended this to June 1st. And, by all accounts, I don't see us getting ready to try a jury trial at, June 1st. So it's going to extend even further. So that means, you have a constitutional right that is now no longer a right anymore. A defendant, one, could be sitting in jail, ready to go to trial, or two, even, someone who's not in jail, is ready to have their case heard. Maybe they need to get a case resolved by a jury trial in order to go on with their job. Maybe their job has suspended them while, the case is pending. So that's like the biggest thing that I think that shocks me. And I don't pretend that I have an answer to this right now. And I know, Jeff, you with the civil courts are exploring, hey, could we do a virtual trial,
right,
jury trial? And again, this situation has forced us to think about these things that we never had to think about before. So I'm not pretending I have the answers right now to how we, make sure a defendant has their civil rights and criminal rights enforced, but I just know that this is an unprecedented time. So that was the first major thing. And then, initially the courts with that first order, the courts kind of went down for all non-essential hearings. Now, I would actually that first week was able to go because I had a couple hearings that were considered essential. So what first was considered essential hearings were first appearance. So if someone got arrested, you have a right to see a judge within 24 hours, and sometimes it could be extended to 48 hours. So that's why there's, court on the weekends for people who get arrested. So those are still in place. There's been a couple procedure modifications to that. Now attorneys can appear by phone, so they don't have to, but, you could still go there in person. It's an essential hearing. So, those arraignments, which are the actual first court date, that's where the state announces formal charges being filed. Those were considered essential hearings. And if usually if a defendant didn't show for one within that first month, the judge is going to plead them not guilty on their behalf and then set the case down the line. So there really wasn't kind of a need for anybody initially to go to court. But now they're allowing certain hearings to proceed forward, as essential, and now even non-essential hearings are being allowed, but most of them are through Zoom, and I've got my first couple ones set next week. but even non-essential hearings, you can, well, let me take that back. Non-essential hearings, you're not going to go to the courthouse for. Non-essential hearings are going to be heard. Now, initially, they weren't going to be heard in the misdemeanor division, only in the felony division. But now non-essential hearings could be heard in that regard. But if you had an essential hearing, you could actually go to the courthouse, whereas, people in the civil end may not be able to have that kind of recourse. But one of the things that I found was when this initially happened, I looked at what were some of the hot things that I had going on that needed to be addressed, and I reached out to the prosecutor. We were able to get a lot of agreed orders right away because they understood the situations, things that weren't big ticket issues but still needed to be addressed. We were able to address right away.
Yeah, well, I mean, we all heard the stories about people being released from jail, which, again, how serious is it if they're actually making those kind of decisions? That's when it really had to be apparent to everybody we were not living in normal times when they're actually letting out nonviolent criminals. And with that being said, with not having a speedy trial, what are you telling your clients right now about that?
Well, exactly what we're discussing here is, one is an unprecedented time, two, just to be patient. And there are people that need to have their cases heard as soon as possible. And then there's those that wouldn't mind if the case extended for 2 or 3 years, because that may be a better situation for them. So, I have understanding clients. Everybody understands what's going on, at least with my clients. But we'll revisit this in a month, when someone says, hey, listen, I need to get this through, what can we do? I will tell you, one of the things that we now are starting to do is we've had cases that are ready to be pled out, and judges are taking pleas, and then they're also allowing what are called pleas in absentia for misdemeanor cases where someone's not going to have to go to jail. The judge can take all the signed paperwork. We kind of do it virtually, and they get the paperwork ahead of time, make sure it's filled out correctly, and then we have a hearing on it, and someone can enter their plea and be adjudicated, with their case on that day without actually physically being present, because they've, sworn to everything being true and correct, and they understand their rights. And that's actually a process that's been going on for years. Out-of-state defendants, a lot of times don't have to fly back in to have their case heard if it's not a serious offense and it's not including jail time, something to that effect. It's been going on for years. Now we're just taking it a step further where in-county defendants might be able to get afforded the same kind of service, as I should say, with this plea in absentia.
Let me ask you this with regards to the clients that you're going with hearings or things you've been hearing around the courthouse. Are defendants able to make first appearances by Zoom right now?
First appearances, no. So first appearances are actually done at the jail. So there's going to be people who are arrested. They're going to be present for that, or they can physically waive their appearance, and the judge is going to just rule. The public defender is going to be there, or private counsel, and the state as well. I have not actually been able to be at a first appearance. However, I got consulted on one right before the defendant was to be, like literally minutes before they were supposed to be in court, and they just proceeded forward, and then the defendant got out because they were issued a bond, so they're now allowing, like I said, the attorneys to appear by phone for that type of hearing. But when anybody's arrested, even if they don't qualify for the public defender, they're going to be appointed a public defender for first appearance.
Sure. Well, that's just something that on some of the webinars I've listened to, some judges have actually brought up the possibility of doing that.
Well, and the idea of a Zoom hearing for a first appearance. It really should be, right now, I'll just use, both in Broward and Palm Beach, there's a lot of satellite jails. And so instead of busing everybody over to one particular jail, for instance, in Palm Beach and Belle Glade, they have a jail facility there. They don't, for first appearance, they don't bus them in. They have closed circuit TV. So there is no reason that couldn't be done. I don't really want to get started on, they should have the ability for lawyers to meet with defendants in the jail. They've set it up in Broward County. They were doing that for years with the public defender's office, but they weren't allowing private attorneys to do that. They have the capabilities. And again, maybe this will force the judicial system and the sheriff's office in both counties to say, hey, listen, there's got to be a better way. And I can tell you, as a practicing criminal defense attorney, there is nothing worse than blowing a half day waiting to visit one client at the jail, because you got to wait for a room. You got to wait to make sure they're not on shift change. You got to, even if you got to ask the client, just 2 or 3 questions, you could blow 2 or 3 hours just for that. There's nothing more frustrating. However, like we're seeing now, if you could have a scheduled Zoom call or whatever, whatever program they want to use, you could literally go through, meet efficiently with the client, have everything explained. I could show documents. I could say, hey, this is the evidence. What do you think about this? We could go through that and really have a meaningful conversation where I'm not waiting till I've got 2 or 3 defendants that I need to see at the jail. We could just, regularly schedule them. I think it would be a lot better for both. It would speed up the process for criminal justice time, for the time a defendant, is in jail, because, a lot of times we're waiting to see them when we get evidence, that kind of stuff. It would speed up the process so much more.
We've brought up a term several times during this conversation, Matt, and for those who may be listening or watching, we kind of take it for granted when we say speedy trial. What exactly does speedy trial mean?
Sure. Great point, Jeff. I'm glad you mentioned that, because, I had a conversation with a client today. I don't expect, my clients to understand all of these terms when I first meet them. That why would, if you've never been in trouble with the law, why would you understand these things? I actually wrote a book, as you know, My Loved One's Been Arrested, What's Next? I actually just, I have my 2nd edition of this. We just
I can't wait to get my autographed copy.
It's in the mail.
Okay.
But it's available on my website for download. But in there, I explain some of these processes. But I do want to explain what speedy trial is. So when someone's arrested, you have a constitutional right. Now, this is by the Florida Constitution. You have a right to be tried within a certain period of time. Now, for a misdemeanor, it's 90 days, and for a felony, it's 175. Now, when basically those aren't the exact dates, because what happens is once speedy trial has expired, you got to file a notice. Then it's a few more days before you get a hearing, and then once the judge has that hearing, it's 10 more days. So it gives you a time period. So as long as a defendant, you don't waive speedy trial, the state has to put up or shut up. That means they have to bring their witnesses. They have to be prepared to go to court. And if they're not, the judge will dismiss the case. And unless there's some good cause, and again, right now, this COVID situation would be a good cause. But, outside of this realm, unless there's a specific good cause, the defendant could have the right to have their case dismissed, and jeopardy would attach, meaning that the state couldn't just refile it, dismiss it and then refile it again. So, the idea that the Supreme Court of Florida is saying, hey, we're taking away this constitutional right because of this unique situation, I think it's huge.
I've never even heard of anything like that, and I can't imagine there's too many times in history where if it has been waived, that it's been waived for this long of a period of time.
Right.
And I'm using the wrong word, not waived, but what do you call it, told?
told, yes, that they say it's basic, like hitting the pause button on your DVR. It's just stopped, and as soon as we get through and we can do it again, they'll unpause it. So,
and what's interesting is if it continues, and again, we talk about virtual trials, Zoom trials, and all that, for those defendants who may be in jail, if that's the only alternative is to have a trial in that fashion, kind of puts them in a very odd predicament.
it absolutely does. And I wouldn't be surprised, depending on how long this goes on, that there are not some sort of civil rights recourses, 1983 actions being held, saying, hey, I have a right to a jury trial. I can get it tried. And, I'm sitting in jail. I'm innocent until proven guilty. And, but what I think is happening right now, and especially, and you mentioned it before, a lot of the jails have kind of opened up, is that they're, taking into consideration this. So, obviously violent felony offenders aren't going to get released. However, drug charges, monetary charge, like a grand theft, something like that. The courts are going to, with an abundance of caution, release someone like that more likely. In fact, I've been contacted quite a bit lately since this for people who have warrants and they've had them for a very long time. Whether they've known about it or not, is a different story. But they're coming to realize, I've got a warrant out there. Oh my gosh, if I get picked up, now I can't just bond out, or I can't just have a quick trial. I could be literally held for a very long period of time. So, with some of those cases, we've been able to actually resolve so that they don't go to jail, so that they're back on what's called pretrial release. And then, and then they'll get their day in court once this kind of clears up.
I mean, it's so much more now than just going to jail, getting picked up. I mean, the reason they're being released is because of the cases they've had in the jails of COVID-19. So I can imagine that you have had clients calling you concerned about their outstanding warrants. I mean, what a terrible time to get picked up. It's not a good time, but I mean, it could be deadly.
Yes. Well, and one of the things that we've seen is an actual decrease in crime because everybody is at home.
Let's talk about that a little bit, because South Florida is, as always, kind of different than the rest of the state. Governor DeSantis is doing a slow reopen for the middle and the northern part of the state, but he says South Florida is not ready yet. So we still have a lot of stay-at-home orders. And what happens if you violate that, Matt?
Well, so the violation of the Health and Safety Act, it's a second-degree misdemeanor, which it's a low-level misdemeanor. It's the lowest it can go. It's punishable up to 60 days in jail and a $500 fine. It is, and I've seen that because I'm just kind of keeping an eye on the booking blotter and what's going on. The people are being arrested right now. If those are additional charges that I've never seen in my entire career practicing, and now we're seeing a whole bunch of new crimes that didn't exist really before. So it's an additional crime, but there was a situation where there was a bunch of teens going around breaking into cars and basically taking advantage of the fact that people were all home. And the state attorney in Palm Beach County, Dave Ehrenberg, said that he was going to look into possibly, because it was a violation of the order, make it an enhancement to any kind of burglary charge that was available. And I'm not exactly sure how he would go about doing that if it's codified in the actual statute, that it could be used as an enhancement. But the idea is that they're going to bring the hammer down more because you took advantage of a situation where everybody is forced to be home and in their home.
Yeah, well, I mean, obviously, with the different changes that are coming down from the Florida Supreme Court in response to this pandemic, for people to be out and about and violating that, it's pretty flagrant and horrible. So you would think that the state attorney would go out of their way to punish the wrongdoers.
Well, yeah, and especially when you're talking about going out in a planned type of event, one of the other upticks in crime, overall crime is down, but in the domestic violence realm, we're seeing an uptick in those as well, and people are, we're all under a huge amount of stress as it is, with this going on. Everybody's trying to work from home. Some people they don't have a job anymore because of this. And so there's a tremendous amount of stress, and then you bottle it up, and then you say you're forcing people to be at home. It can be a ticking time bomb. So we're seeing more domestic violences out there, and and those are cases where on a domestic violence case, you don't get a notice to appear and avoid arrest. No, that's something that you have to be arrested, see the first appearance judge so they can issue a temporary stay away order. And then now that person can't go back to the home that they were ordered to stay at. So there's a whole bunch of new problems that arise with those types of cases. But, those are an uptick. And believe it or not, Jeff, there's still people getting out and getting DUIs right now. And whether or not that's because somebody's at home getting bored, drinking, and then saying, I just gotta get out of here. I don't know if you saw that about a month ago, the UFC fighter John Jones was arrested for DUI.
Yes.
And he just said to the officer, I was bored. I went for a joyride, and
figured nobody's on the roads.
Yeah.
Figured he got his discount from his insurance company. He's like, oh, well, nobody's out there anyway.
Yeah, I mean, I don't know what you did with your $30.
I think I ordered a movie or something, maybe. Maybe bought some extra popcorn. I don't know. Not much. I may have used it for ordering WWE pay-per-views. So how about WrestleMania in front of no audience this year, Matt?
Yeah, I'm going to reserve comment on it. You know how much I love wrestling, and I was happy that I had something new to watch, but it really wasn't the same thing, was it?
No, it was definitely a little bit of a distraction, but wrestling is sort of like the Rocky Horror Picture Show. Without an audience, I don't think it's worth watching. The chants, the different.
Good call.
Yeah, I mean, people ask me about that. I'm like, yeah, it's kind of like that. And if you've ever been to the Rocky Horror Picture Show live with, people acting it out, that's the best. The movie's terrible, but the people make the experience.
So are you kind of saying it's like a mime without an audience?
A little bit.
Yeah.
Well, let me ask you. You brought in your book. Can you just briefly tell everybody what's in there,
Sure.
how they can get it, just the title, and I know you're very proud of that, and I've read through it. It's fantastic.
Thanks.
The first edition. I need to read the second edition. I'm very excited about it.
So the book is called My Loved One's Been Arrested, What's Next? And basically it's the guide for, the mother who gets a call that their son was just arrested, or the husband and wife, or the friend. And so basically it kind of spells out what that person should do. And the first thing is not to freak out. Obviously this is, your loved one committed a mass murder. It's time to freak out. But, we're talking about this, Jeff, my practice consists of regular people that made a mistake, and there's varying degrees of that. There's some career criminals, but there's, a lot of my clients are first-time offenders, and they don't have any kind of history with the law, and they never will again. So this book kind of gives the family an idea of what they can do, how to calm themselves down, understanding this roadmap. We take for granted that we've been practicing law 18 years now. We've done these types of cases. We're pretty familiar. We know what we can anticipate what can happen. But for someone who has only watched, court TV shows that aren't realistic, they have a different expectation. This book kind of gives you an expectation of what to expect. It defines, kind of what we talked about before, what people's speedy trial rights are, but it also gives you, like if you, had someone arrested, how to go about finding a bondsman, how to go about finding an attorney, because, other people, from across the country have ordered this book. And while, it really pertains to Florida, it gives you things to ask. One of the questions I think is what people think to ask a lawyer when they're interviewing is, what's your win-loss record? Well, when you're doing criminal defense, you already have the cards stacked against you. And what is a win for some person might be a loss for another, or what might be considered a loss for one person could be a huge win. And I give you the example. I had a client charged with, 4 felony counts of varying domestic assault type situations. We went to trial, and he was found not guilty on 3, and he got a misdemeanor charge of battery. Well, that was a huge win. But if you wanted to look, I lost that count. So that could be considered a loss. It's not, the wins and losses really don't matter. It's, look at, things to think about are simple things like look at client reviews. If look at what those previous clients are saying about the lawyer. Are they honest? Are they trustworthy? Do they return the phone calls? Because you can hire the best lawyer in the world, but if he doesn't return your phone call, what good is that to you? You're going to walk around on eggshells until your day in court. So kind of gives you that kind of process, an expectation of how long a court case is going to take. And then, what could be alternatives to going to trial. So that was kind of the object of the first, the first edition of the book. The second edition, I started thinking about it. I have a lot of defendants, requesting this book. So then I put in, well, what if it's you, what to do, which it just kind of varies the first part of the book. And then we talk about what happens after trial if you get placed on probation, or, if you take a plea and you go on probation. And then the last thing that I'm finding most people are interested in is, how do you get your record clean if you are successful? So we talk about the expungement process, and now even getting your mugshot removed, because you can have an expungement and your mugshot can be plastered still all over the internet. And because they're private companies, they're not really required to take them down, unless there's a few circumstances, and I explain that in the book. So thank you for letting me get my plug in.
Such a cruel thing to do to somebody, for getting arrested, to have that out there by these private companies. I've just always felt very uneasy about that.
Absolutely. So thank you for giving me the opportunity to talk about this.
Well, listen, I had you on. I know what kind of work that you do. I've referred many people to you over the years. And like you said, if people go and look at your client reviews, they would see why, because you do return calls, you give practical advice, and your results speak for themselves. So if anyone wants to get in touch with you, Matt, can you tell them how to do that?
Yeah, the simple way is you can go onto my website, which is 561law.com. It'll bring you to the bigger domain name, which is matthewkoneckypa.com. But there's a lot of resources. There's videos. Not only is there this book, there's a couple other informational guides available for download there. Our number is 561-671-5995. You can give us a call. We have a satellite office in Fort Lauderdale. I really will handle, under the right circumstances, everything from Dade County up to St. Lucie County. But, try to keep it in the Broward and Palm Beach County area.
So if you're going to commit a crime, you prefer those two counties?
Yes. I'm gonna bite my tongue.
Sorry, I had to. Well, what'd you say? I'm sorry.
I'm gonna bite my tongue right now.
Yeah. I had to give you a little teasing. Well, again, I can't think of anybody better to have on the show on this very, very festive Rusev Day. I appreciate you being on with me. It's always a pleasure, and I think that anybody who's watching this or listening, you gave a lot of really valuable information during this unusual time, but practical information really for any time, Matt.
Well, I appreciate that, Jeff, and I appreciate all the work that you're doing with the ABOTA. You're keeping us lawyers informed about what the courts are doing and how to make best use of the resources out there to keep these cases moving. And like my clients that want a resolve to their case, your clients want that same kind of resolve. And right now we're in this area of time where it's hard to move a case, but it can be done, as you're finding too.
Well, I appreciate that, Matt. Well, if you ever want to get in touch with me, again, my name is Jeff Adelman. The number is 954-341-2777. We're going to continue this great interview show where I'm going to continue bringing you top attorneys in the area to talk about how you can have the best legal knowledge possible. And they will answer the questions that you may be initially afraid to ask or might not know that you need to ask. So again, Matt Konecky, thank you so much for your time. Thanks, to you Jeff. Soon. Goodbye, everybody.
Bye.